Okay. I do want to talk a little bit about probate and estate administration. Everybody's heard of probate. You hear a lot of rumors about probate. You hear it's a bad thing. Like I've said, in Colorado, it's really not that bad. It's a legal process to appoint a personal representative, to pay creditors, and then to distribute any remaining property. That's really all the probate process is. We take the will, we go to the court, and we say, hey judge, this is the will. And usually it's not even a judge these days, usually it's just the probate clerk. They look at it and they go, yep, that looks like the will, and they accept it, okay? That's really probate. At that point, somebody has asked to be named PR because they're nominated in the will, or if there is no will, they have standing under the law. And so they ask the court to be named the PR, and the PR gets appointed by the court. The court issues some letters and some orders and different things. And then basically at that point, you just go and you do the administration piece. You only need to go back to court if you need something. If you need a judge's input, if there's a fight about something, those kinds of things. So again, Colorado probate is usually very simple, inexpensive, and administrative. If you own property in another state, real property, land, house, that sort of thing, you will have to do an ancillary probate proceeding in that state. That's another reason a lot of folks in Colorado will do a trust. They'll do a trust just to get that out-of-state property put in a trust so they don't have to do that ancillary proceeding. That's another reason we use trusts. But probate occurs whether or not there's a will. So it doesn't matter if you have a will or not. If you have assets that have to go through probate, you've got to go through probate. Okay? And now, remember those three columns. If everything's owned in joint tenancy, if you've got a married couple and one person dies and they own everything together, you're not going to need to go to probate because the spouse is just going to take everything, right? But say I have a bunch of things that are just in my name. They're not my husband's name. I've got bank accounts just in my name. My car is only in my name. Things like that. If I die, my family's going to have to go through probate to get those assets distributed. If the deceased person owned any real estate that wasn't in joint tenancy or they didn't have a beneficiary deed, if they own it outright by themselves, we have to go through probate in order to take care of that property. If they owned assets with a value of $66,000, that number changes occasionally, but I believe right now it's $66,000. If they own more than that in his or her own name after expenses, you've got to go through probate. So maybe they don't own real estate, but they've got $100,000 sitting in a bank account, and it's just their name on it. It's going to have to go through probate to get to that money. So again, non-probate assets don't count for that $66,000. So if they had joint tenancy in the house, that doesn't count. If they had joint tenancy on bank accounts, or if they did payable on death designations, those kinds of things, again, are going outside probate. So probate gets a little complicated in places. But there is also a small estate affidavit in Colorado. This is very useful. If someone has no real estate, or if they took care of their real estate some other way, and they don't have assets worth $66,000, then you can actually do this affidavit and you take it to the court and you're able to take care of things much more simply. You don't even have to go through probate. Okay? So we have a lot of great sort of simplified options in Colorado.